All right. I mean, not now, but I mean, in the future, for future business,
Fair enough. Okay, I move the amendments.
some movements have been moved, seconded. Now the bills before you as amended. Senator Fulton, go ahead.
What is the measurable standard? Like, what is the level that they're measuring to?
So the levels are actually in Comar, so the relevant article in the code directs, I believe it's the MVA to set the limits, and basically if you're above those limits, you're in violation of the.
Do we know what
Statutory
the limits
provision.
are? It's in decibels, I imagine.
It is, yes,
And
and it's based on the type of the vehicle.
all right, thank you.
All right, so now the bill is before, sorry, Senator Sidnor.
I remember Senator Muse talking about Prince George's. So who's in which counties?
So now it's Prince George's, Anne Arundel, and Montgomery.
All right, so it hasn't changed then.
It has changed because we added in Anne Arundel.
No, they were already in it.
Yeah,
With-
through the amendments.
Right.
Yeah,
Okay,
but we got the bless off from Anne Arundel County to be added in.
okay.
And Ronald was in and they were out.
And now they're back in.
I wish I had that type of power. All right, so bills before you as amended. Motions for favorable seconded. Is everyone okay being recorded in the affirmative? Senator Fulton is down. So Senator McKay is down and Prince George's, Montgomery, and Anne Arundel. All right. So bill passes 9-2.
Which bill?
This is Senate Bill 229. With amendment. Now moving on to Senate Bill 679. All right, sure. We can reconsider. All right, so then the motions to reconsider the vote by which the last bill passed. Everyone's okay with that? Great. All right, now the bills before you is amended. There's another pending amendment. The amendment is to have Senator Washington and Senator Muse, and I'll jump on Senator Smith. Senator Wallstreger is going to jump on. Senator Kelly doesn't have any noise in her District 16, so she's good to go. No, all right. I'm sorry. All right. Senator Kelly's on. So the amendment is to add Senators Muse, Waldstreicher, Washington, Kelly, and Smith. Oh.
Oh, what? Yeah, no.
All right, the amendment's been moved, seconded. Everyone's okay with the amendment. Now the bill's before you as amendment with two amendments. Motions for favorable has been seconded. It's been seconded. We're going to record the same vote. Senators Fulton and McKay are negative. Everyone else is up. Okay. All right, bill passes with amendment. So you got it?
Was that 229?
Yeah, the same one. Senate Bill 229. All right, now we are on Senate Bill 679.
Senate Bill 679 authorizes the placement of speed cameras in Anne Arundel County on highways and residential districts with a maximum posted speed limit of 35 miles per hour. This matches the authorization currently in law for Montgomery and Prince George's counties.
Delegation letter.
We have
Local bill.
Okay, Senator Sidnor, go ahead.
I'm almost to the point of just saying, why don't we get rid of work zone and school zone cameras if everybody wants these cameras? I mean, that's once you start bringing them into residential, that's where we're going.
Yep.
And I can tell you that, I mean, this bill, our House delegation considered this over in the House and it failed because, and I know the people they were looking, they said, well, I think they said Montgomery County and Prince George's does it. So now we're going to add Anne Arundel, which means I know it's coming back. I'm not sure why I am on this.
There's a motion for a favorable. First, it's been second, you can go down on it. Motion for favorable has been seconded. We do a roll call?
Yes.
No.
Yes. Yes.
No.
Oh.
Based on Senator Senior's very compelling comments, I am worried about the expansion of this, and I'm worried about it going into other counties. And I'm worried about how money is collected. So I'm no.
Senator Washington,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Nay.
Senator Carter,
Yes.
Chair Smith,
Yes. What was the final vote?
7-4.
All right.
Okay.
So Senate Bill 679 passes 7-4. All right, next we will have Senate Bill 252.
Senate Bill 252 specifies that a person charged with a reckless or negligent driving offense that contributes to an accident resulting in the death of another must appear in court and may not prepay the fine. There's an amendment in your new voting packet for tonight. That's number 933221/1. What the amendment does is add a 5-day incarceration penalty for the offense of reckless driving, regardless of whether it contributes to an accident that results in the death of another. And in addition, it keeps the change in the original bill as it relates to negligent driving. So under the bill, if you are charged with negligent driving that contributes to an accident resulting in a death, you would have a must appear citation. And if you're charged with reckless driving, no matter what the consequence, there would be a maximum penalty of 5 days incarceration or a $1,000 fine or both. No, it's not mandatory.
Yeah, so Senate, instead of doing the racing stuff, this is the way we're getting at it. Just because this is.
Time is to ask to be added on as a co-sponsor, but that's all. I'd like to be added.
Let me go ahead and move this amendment first, then. Good.
Okay.
So this amendment's moved, it's been adopted, seconded. All right. You, Senator Washington, do you have a question or? Oh, sure. Senator Washington first, then we'll do the amendment.
So this increases, there's no jail time before they have to go through, before they have to be adjudicated through the court system, right? But this would add imprisonment if they did not show up.
So there would be a potential maximum 5-day incarceration once you're adjudicated guilty on the reckless driving offense.
So just explain, so for Pennsylvania, Virginia, West Virginia, North Carolina, they all have reckless.
Yeah, for all of those states, their reckless driving statute carries a potential penalty of incarceration. So this would bring us into that group, although it would,
30 to 90 days.
yeah, it would be a smaller potential penalty, but
So this is in lieu of the race car driving, like because it's more elegant, I think, but it's just. Those, we're never gonna get to that point where we have all the fences coupled and skated wheels, and it's too complicated. It's in Worcester County. If you plus it up statewide, it's probably subject to a lot of abuse, but. Yeah, but. Yeah, sure.
The other component of this is it alleviates where law enforcement currently, if there's a fatal crash involved in one of these exhibition things we're talking about, you can only issue a payable citation. And then what happens is they can pay that citation. And if there was any charges that were going to be investigated subsequent to that for like vehicular manslaughter, you can't do it because they've already adjudicated by being given that payable citation. So this allows them to issue the citation. They have to come to court. And then if the investigation were to evolve, that other evidence were to become in place, they could then have that all under the same hearing, which would then hold them accountable to be in front of a judge for the offense. That's the other idea behind it.
I hear it, but what's the definition of reckless driving?
A motor vehicle in a willful or wanton disregard for persons or property.
Got it. And does that include going over like 15 miles per hour over the speed limit? Does it include that?
30 over.
30,
No, there's-
okay.
So there's no
Nothing
per
in
se rule on that in Maryland. I
No.
think Virginia has such a rule. It would be up to the, the discretion in the individual case, whether
Is
speeding
that
constitute a
discretion of the police officer that arrives to the scene then to
on on an initial charge, yes. And then, the state's attorney would make a decision if it would go to court.
You can't put any kind of framework or definition for or limitation.
This is what we're trying to avoid, was the whole issue
That's the
of trying to single out things.
Oh,
This is what we were trying to avoid.
Gotcha. Okay.
Reckless has been in motor vehicle law forever.
Common law.
So it's just a matter of making it where people would be held accountable. And it would encompass what we're trying to accomplish with the exhibition issues that we're having in the more.
And the bill as amended does not take it, like the negligent driving, you can only be arrested if it results in death.
Yes.
So.
You can't be arrested at all. So it becomes a must
You must appear,
appear.
sorry, it's a must
So you
appear,
get the
sorry.
citation, you have to go to court
Correct.
to have the citation
Yeah,
I
adjudicated.
guess if you didn't show up.
If it contributes to an accident that results in death.
Yeah, correct. Correct.
Correct.
Yeah, it's not mandatory.
Yeah.
It's not mandatory. Yeah.
So did we adopt the amendment yet?
Yes.
We did. Okay, so there's another forthcoming amendment, sponsor amendment.
Mhm.
Senator Folden wants to be on.
Come join me. Come on, let's go.
Senator James is already on the bill.
Oh, yeah. Yeah.
All right, is everyone okay with
I'd
having
like to-
Senator
I'd like to do that.
West would like to be on the bill?
James.
Senator, I think she's already on the bill. Senator West, Senator Folden.
West is already on.
Wes is already on.
West is already on it. Okay.
Folden.
Senator Folden, all right.
Yep.
Is everyone okay? So now motions for Folden, seconded, everyone's okay?
Yep.
All right, now the bill is before you as amended,
Move favorable.
seconded. Everyone okay, being recorded in the affirmative? All right, excellent. Senate Bill 252 passes unanimously. We'll now move on to Senate Bill 340.
Senate Bill 340 establishes prohibitions relating to making a false statement, report, or complaint of an emergency, which is defined in the bill, or alleging the commission of a crime to a government emergency report recipient, which is also defined in the bill. Violators are subject to the criminal penalties and are civilly liable, as specified in the bill, specifically for a person who causes to be made a statement, report, or complaint of an emergency or alleging the commission of a crime that the person knows to be false in whole or in material part to a governmental emergency report recipient with reckless disregard of causing bodily harm to an individual, and as a direct result of a response to the statement, report, or complaint. That's subject to 3 years and a fine of up to $2,000. If the result of the act is response from law enforcement and serious physical injury or severe emotional distress, or death of a person as approximate result, then it's subject to 10 years and or $20,000 maximum penalties.
So as many of you know, swatting is an increasing problem in our community and is particularly utilized in two communities, the white supremacist community, which often targets people of color, and gamers, who often target each other. But sometimes there's overlap between those two subcultures where white supremacist gamers use swatting to attack people of color who are also gamers. So currently Maryland doesn't have a law against swatting. Many other states have adopted it. Over the past couple of years, a number of members have submitted swatting legislation in different forms. And so instead of trying to figure out, choose between different swatting bills that have come before us in previous years, we put together last year a task force with everyone at the table. So this is kind of the kumbaya bill that resulted from that task force with everyone in agreement in favor of the legislation.
Just so lines 23 through 26 on page 3. It says it's a felony with an imprisonment not exceeding 10 years. Where did that come from? Is that consistent with these types of laws?
I think that's a wide question, so I think that's Senator Waldstraker.
Sure. So there's different penalties for different levels. So the 10-year penalty is where where the result was, if you refer back to B2. That's where there's serious physical injury or severe emotional distress or the death of a person as a result of the conduct. And so that's where there's a more severe result, there's a more severe penalty. We didn't want kids to kind of get overly penalized for this. And so that's why you see beginning on line 27, a first-time violation of this section by a minor is a civil offense. So basically, for the first time, if you're a minor, you get essentially a ticket for this, because we didn't want to jam up children and provide them with a criminal record so early in their life. We want to use this as essentially a learning opportunity for them.
And the term on line 17, severe emotional distress. What can you talk about what that is?
I'm looking up to see if that's a defined term in the bill or whether it's otherwise defined at law.
No.
Yeah, let me, if you give me a minute.
That's it. That was it.
Oh, so I was going to echo exactly what Senator Sidnor is bringing up. You know, we have a felony up to 10 years. We were just debating about a 5-day penalty for someone that's in a car that kills somebody. And we're talking about a felony up to 10 years for a subjective standard of severe emotional distress. That's based on someone's feelings. So, I mean, that's got to be cut out of there. That's not a measurable standard at all.
Well, not everything at law is objectively measurable, but nonetheless, I understand your concern. I think the idea was to get at where there is a result that is severe, where what happens, where we think what might happen actually happens, there should be a more severe penalty. So I'm getting where you're going. Assuming we don't have a definition of law here, and I'll refer to Jamie.
Yes, we don't have a penalty that's severe for an
No,
assault.
where I'm going is I want to hear what the definition is, but I think I'm amenable to taking it out.
Well, the closest criminal penalty that I can find that uses the term severe emotional distress also doesn't define the term, but it is 3605 of the criminal law article, which is abuse or neglect of a vulnerable adult in the second degree. that provides that household member or family member may not intentionally and maliciously inflict severe emotional distress. So it's not. Sure, no,
This is not about carrying custody.
definitely a different offense, but
Yeah.
just
I understand.
that's the only similar provision in.
Yeah, I
in
mean,
criminal
the
law
difference
that I'm
being in
pulling
that
up.
one, you have care and custody. The difference being in this one is someone does something that's not appropriate, but we're gonna make it a felony with.
That's a good flag. I'm fine taking it out. It's the phrase severe emotional distress. So it would,
What's the penalty, Jamie, for, sorry. What's the penalty for an assault?
Second degree, 10 years.
Is it a felony?
Depends on,
So I'm better off to come up and just not do a swatting call, but slug them and I get less penalty than if I call in this and I mean, I support I support what this is about. The penalty is a little bit, in my opinion, going a little haywire, that the penalty doesn't necessarily match the crime. I mean,
if you take out emotional distress, the B2 only applies where there's serious physical injury or the death. And serious physical injury is serious.
I understand, but.
Yep.
we're making it a felony.
Where that is the result.
I get it.
Yep.
You can assault somebody and have a serious bodily injury. It's not a felony. You can physically assault them.
So if you just do it and there is no result, it's a misdemeanor. And then where the result is serious physical injury or death, then it's a felony.
And shoot the person inside and he doesn't die. That's serious physical injury. The person who's caused that ought to go to jail for a long time.
Great conversation. Hey, can I, yeah, my question here is about the work group. Who comprised of the work group? Do we know that, or is that anywhere?
So council can get that.
Okay.
But it include the public defender's office was represented, state's attorney's office was represented. The ADL, the Anti-Defamation League, was represented. They were the chair. There were both Democrats and Republicans on it. Everyone seemed to come together, so.
Got it. And I was gonna ask, how many of these cases are known in the state that haven't been prosecuted or could not, or would have fallen under this law if it was passed?
Because it's not currently a crime, I don't think we have an answer to that. Because there's no way to track without having it be a crime that can be prosecuted.
Got it. Okay, but we know that it's happening.
We definitely know that it's happening. Yeah, no, it's it's happened a bunch. I think there was a prominent journalist in Senator Kelly's district where it happened. But can we go back to Josh, excuse me, to.
sure.
Yeah, thank you.
I'm looking at the report and unfortunately it doesn't say what organizations they were from. Why don't you pull up the bill from last year? Just a minute.
Yeah, I mean, I'll just say I'm concerned about a senior in my district that, or anywhere in the state of Maryland, that might make a call and just concerned about a neighbor or something, but she's constantly concerned about it and she calls and gets kind of messed up in this, and she's very concerned, but maybe the person has Alzheimer's or something and calls in. How do we prevent that from happening, or those types of situations from happening? Well, let's take about the Alzheimer's piece. Let's just talk about the person is a senior and calls in and is concerned and could fall under this. How do we prevent her from falling into this?
Sure, that's a good question. So the bill, by its very definition, the person has to know that the report is false. So the report doesn't just happen to be false. The person making the phone call has to know that the report is false in order to be prosecuted under the bill.
Got it. And there'll be an investigation to figure out like if that person knew that or not.
Correct.
Got it. Okay. I would just say that I'm concerned about the 10-year penalty. And I'll just throw it out there.
So the members were, you had three from the Senate, appointed by the President of the Senate, three from the House, appointed by the Speaker, the Public Defender, the Chair of ADL, Executive Director of Maryland Chiefs of Police Association, Executive Director of the Sheriff's Association, President of the State's Attorneys Association, President of the Maryland Conference of the NAACP, and staff by OAG.
Thanks.
Thank you, Mr. Chairman. So I just wanted to, I heard what Senator Washington says, and he brings up a valid point. Because I can tell you that I have been summons to calls where a lady was saying that her neighbor downstairs was being raped. And she suffered, and she would make these calls frequently, but it would be potentially a different location. And she suffered from mental illness. The problem is that we still have to respond and to each call, and she would call a lot. So in her situation, the way I read this, she could be, if police are doing their due diligence and respond, she could be found in violation of this and jailed, which, listen, I'll be honest with you, I'm okay with that. Y'all know me. But I'm not going to say it's fair in this situation. It's not, the intent is good. I have concerns about, like Senator Washington saying, that there's groups that, the feeling thing, I'm glad we cut that out, but I do have concerns about it.
I'll just read the relevant part because I don't think the person could be prosecuted in that case. So the relevant part says, the operative language, a person may not make or cause to be made a statement, report, or complaint of an emergency or alleging the commission of a crime that the person knows to be false as a whole or a material part to a governmental emergency report recipient with reckless disregard of causing bodily harm to an individual as a direct result of a response to the statement, report, or complaint. So the person needs to have at least two things here. They have to know that the allegation of the crime is false, and they have to make the call with reckless disregard for causing harm to the person that they're calling it in on. And so I can't imagine in the circumstances in which you indicated that anyone would be prosecuted, but more importantly, based on the language here, I don't think anyone could be prosecuted.
So you think in the text, yeah. You're up.
Are you finished?
Yeah.
Okay, so actually, I had the same question. It's a good thing when you're late. I had probably the same language that Bolden had. Vice Chair just said he's amenable to reconsidering it. And I also want to know who's on the council. And but it's interesting because the public defender was on the council or the commissioner, task force, or whatever it was, but they did submit unfavorable testimony, right?
Correct.
So I don't know that it was fully agreement. It sounds like the thing was kind of not way.
Yeah, OPD was unfavorable.
They were unfavorable?
Yeah.
Who else? Anybody else?
Because the prosecution.
No, because it,
That's what it says.
okay.
I
I was thinking it was more in line because it okay. So,
Already have adequate punishment that holds kids responsible, still acknowledges that they are children. Got lots of other bills that said people are children until they're 25. Such of these attacks are targeting schools. Maryland Code of Education, disturbing activities at school and colleges, molesting, threatening students. So I don't, we're doing this and doing that.
no, it's okay. I know I got distracted now, but so the bill was before us, as you stated, Mr. Vice Chair, for several years. And it never seemed to make it through for at least 2020, 2021, and 2022. And then this task force came together. How is the bill today different than the prior versions?
Really good question. So my sense is, can't speak for the whole committee, but my sense is that the bills didn't move forward, not because there wasn't a political will to do something, but because, as with any novel issue, different people were putting in different bills, and we just ran out of time to kind of put them into one bill and figure out the way through. And that's why the task force was put together. And so I think the biggest differences are this bill is much more nuanced than previous legislation. So we had legislation that did what I think Senator Washington had concern about, where no matter the result, the crime was a felony. So if you called in a swatting offense and nothing happened, in some versions of previous legislation, that was a felony. There was versions of the bill that did not provide an exception for children. And so children could get caught up in the criminal justice system for calling in a threat to their school, when in fact, that's really more of an educational moment for kids, at least for the first offense. And so what the task force was able to do, with including the ADL and the NAACP and others, was come together and try to craft a more nuanced version of the law that better delineated the punishment for the crime. And so here's the structure of the bill as I understand it, where you call in a SWAT team knowing that it's false, even though the resource use is intensive, as Senator Folden mentioned. If nothing comes of it, in other words, if no one is harmed, then that's a misdemeanor. If you participate in swatting and someone gets hurt, which is a likely outcome of a swatting situation, someone gets seriously physically injured or dies, that's a felony. And then the last kind of nuance that distinguishes this bill from previous bills is that it treats children as children, and says that for a first-time offense, a minor will receive a citation, which is a non-criminal, a civil citation, same as like a traffic offense, which is a non-criminal ticket essentially, but also provides an educational moment, an opportunity for intervention to indicate to the child why this is dangerous. And so that's why the task force was able to be so successful, because it brought more nuance and distinction to the legislation.
I went to look at something else similar, and it is kind of in line with another bill we passed last year. But shouldn't intent have something to do with it, not just the outcome? Is it in there? All right.
All right, how many?
Strike out the severe emotional distress.
Yeah.
Second.
All right, there's been a motion and seconded. Is everyone okay adopting the amendment? Great. Now the bill's before you as amended. Discussion. Someone want to make a motion? So do we need a roll call, or is everyone okay being recorded in the affirmative? All right.
Something that hard to live with. I support the bill. I just say
Oh, yeah, that's fine. All right. All right, so bill passes with amendment. It's 10-1. Senate Bill 340 passes 10-1. All right, now we're going to go on to Shamari. Senate Bill 5.
That would constitute a violation of 10-304 of the criminal law article, which deals with hate crimes, to bring a civil action against the perpetrator. As amended, the bill clarifies that a victim must suffer a demonstrable harm beyond mere exposure to the act. Yesterday, Senator James had asked about whether reasonable harm had been codified elsewhere. I was unable to find any other place in the code where it is.
Okay, hold on a second. Just no amendment, just the bill straight.
Okay,
Sorry, yeah, sorry.
yes, sorry. You don't want me to describe the amendment? No, okay. So the bill provides a civil remedy for people who are the victim of hate crimes.
Oh, okay.
Yeah, I'm not entering it. Apparently not. That amendment doesn't exist anymore, so just it's thought should be out of your mind. Motions for favorable. Second, is everyone okay being recorded in the affirmative? Okay, next. All right. Bill passes unanimously. All right, now we're on Josh, we're gonna go on to Senate Bill. Senate Bill 859.
Senate Bill 859 generally limits the ability of the state to participate in or support investigations, foreign judgments, and disciplinary actions related to the provision of legally protected healthcare, which is defined in the bill as all reproductive health services, medications, and supplies related to the direct provision or support of the provision of care related to pregnancy, contraception, assisted reproduction, and abortion that is lawful in the state of Maryland. You want me to walk through?
Yes, go ahead.
So turning to the specific provisions in the bill, starting on page 2 in the Courts and Judicial Proceedings article, section 9-302 deals with the ability of courts to enforce summons from other states in criminal investigations. So on page 3 of the bill would create an exception to the ability of courts to do this in cases where the underlying violation is related to the provision of legally protected healthcare, unless the acts forming the basis for the prosecution or investigation would constitute a crime in the state of Maryland. Moving on to section 9-402. This section concerns the Maryland court's enforcement of subpoenas issued in other states. It would additionally prohibit the enforcement of subpoenas for which any portion of the subpoena is intended or anticipated to further any investigation or proceeding related to legally protected healthcare, with an exception if the out-of-state proceeding is an action for damages, is a claim for which a similar or equivalent claim would exist in the state of Maryland, and is either brought by a patient who received the legally protected healthcare or based on conduct that would be prohibited under the laws of the state of Maryland. Moving on to section 10-408, which is on page 4. This provision deals with ex parte orders, which are applications to a court to grant an order to conduct wiretaps or electronic surveillance. Starting on page 5 of the bill, it creates an exception to the ability of a court to grant such an order if the order is for the purpose of investigating or recovering evidence of actions related to legally protected healthcare. Moving on page 5 to section 11-802. This section deals with the court's ability to execute judgments issued in others by the courts of other states. Starting on the bottom of page 5 and carrying on into page 6, the bill would prohibit the execution of such judgments except as required by federal law. And again, there's an exception which covers judgments which are where the underlying cause of action is an action for damages for which there is a claim for which a similar or equivalent claim would exist in the state of Maryland and are either brought by a patient who received the legally protected healthcare or are based on conduct that would be prohibited under the laws of Maryland. Moving on to the criminal procedure article, section 9-106 deals with permissive extradition, where another state is requesting that a person present in the state of Maryland be extradited to that state to face charges. So the bill would create an exception where, unless compelled by a writ of mandamus issued by a federal court, the governor may not surrender a person if the alleged act for which the surrender is being demanded relates to providing, procuring, or aiding another in providing or procuring legally protected healthcare services, and the act would not be a crime in the state of Maryland. Moving on to the health occupations article, section 1-227, which is being added by the bill, prohibits health occupations boards from disciplining a health professional for actions related to their provision of legally protected healthcare, so long as the legally protected healthcare was provided in accordance with the standard of care as determined by the relevant health occupations board and the laws of the state. Moving on to the insurance article, section 15-857 deals with provisions of last year's Abortion Care Access Act, and specifically the application of the requirement in that bill that health plans cover abortion services without copays or deductibles to high deductible healthcare plans. Moving on to section 19-117 of the insurance article. This is a prohibition on medical malpractice insurance providers taking adverse actions against healthcare professionals based on their provision of legally protected healthcare. And then finally, in the state personnel and pensions article, section 2-312, this prohibits the state or state personnel or local governments or local government personnel from participating in investigations related to the provision of legally protected healthcare, with specified exceptions, which are where the investigation or proceeding concerns conduct that would be subject to civil or criminal liability or administrative sanction if it was committed in the state of Maryland, as well as an exception for where the subject of the investigation or proceeding submits a written request to provide information or assistance to the investigation or proceeding. So there are two amendments in your packet. First is from Senator West, which is amendment number 143521/1. So this amendment would simply clarify that when it comes to the provisions of the bill relating to medical malpractice insurance, that an adverse action does not include basically the standard procedure by which medical malpractice insurers have to get their rates approved by the Maryland Insurance Administration. And the second amendment in your packet is number, do you want to?
Yeah, let's do that. Like, I'd like to adopt this amendment. We can discuss it, adopt it, and then adopt the second set of amendments, and then we can discuss the bill as amended. So Senator West, do you want to explain your amendment, or it's?
I must be getting old. I think I submitted a while ago and I don't have it in front of me, so it'd be better.
Council explain it.
Yeah, so you have a reprint. It's the amendment is number 143521/1. So it is on, let's see, page. Yeah, the amendment language is on page 9, which is the provisions of the bill relating to the prohibition on medical malpractice insurers taking adverse actions against healthcare providers based on their provision of legally protected healthcare. So it's that new paragraph 2 there. Adverse action does not include making a rate filing in accordance with section 11-206 of the insurance article, which is, that's the process by which medical malpractice insurers have to submit their rates to the Maryland Insurance Administration for approval. And they may have to make modifications to those rates if the administration deems them excessive or unreasonable.
Yeah. So the insurance companies make these rate requests annually based on all the information that comes into their possession. And you wouldn't want them, we wouldn't want to hold it against them that they've asked for a rate increase on the basis of this bill.
Correct.
So
So I'll move the amendment. Seconded by Senator Kelly. Is everyone okay with the amendment? All right. Second amendment, then we just- these amendments.
So the other amendment is number 813125/1. This makes several changes to the bill. So if you turn to the reprint on page 5 of 10, it adds an exception to the prohibition on the bill on granting ex parte orders, which would read, unless the acts forming the basis for the investigation or recovery of evidence would constitute a crime in this state. The next change is on page 7 of 10. It makes some clarifications to the language regarding the prohibition on health occupations boards taking disciplinary actions based on the provision of legally protected healthcare. So it would simply add, basically it would clarify that you're talking about an authorization to practice for any healthcare practitioner. And then it would also clarify that the prohibition applies so long as the legally protected healthcare was provided in accordance with the standard of care as determined by the relevant health occupations board. And this one word isn't in the amendment in the reprint, but it should read the relevant health occupations board established under this article and in accordance with the laws of this state. So it's adding that piece that's clarifying that the legally protected healthcare has to be in accordance with the standard of care as determined by the relevant health occupations board, as opposed to simply in accordance with the laws of the state. I think it clarifies some ambiguity on that point.
When you say this, just in Maryland.
Right, in the state of Maryland. The next change is on page 9 of 10 of the reprint. And this simply clarifies that in the provisions related to the prohibition on medical malpractice insurance carriers taking adverse actions against healthcare providers, that it includes not only the actual provision of legally protected healthcare, but also a referral for legally protected healthcare. And the final change is on page 10 of 10, which is to change the effective date of the bill from October 1st, 2023 to June 1st, 2023.
So just move the amendments. We can discuss the bill as amended. All right, is everyone okay with that? So we are primary, but is finance is secondary?
Finance is second.
All right.
Question, just a comment. I think amendment number 3 is really great and helpful and clarifying, and I appreciate it. Thank you.
Is- I'm gonna do a motion for favorable.
Second.
So, with amendments. We can do a roll call.
This, as it's written, would stop another state from summoning or subpoenaing, charging, whatever, asking us to take into custody a person who that in their state would have been an offense, but they came to Maryland and had a procedure done.
So it would depend
That
on.
it's legal. in
Yeah, it would depend on where the offense happened. So if the person being extradited was physically present in the other state at the time, that would be subject to the mandatory extradition provision in the federal constitution.
So if they did it in their home state where it's illegal and then moved to Maryland, you're saying that Maryland would not be able to?
They would have to extradite under the mandatory extradition provision in the federal constitution.
They would have to extradite in that circuit.
Yeah, so the difference is the federal extradition provision in the Constitution applies where a person commits an offense while physically present in one state
Mhm.
and then flees from that state to another. So the state in which they committed the offense could request extradition from the state to which they fled, and the asylum state there would be obligated to return them to the demanding state. The permissive extradition scenario is when somebody in, say, Maryland or a third state commits an act which results in a crime occurring in the demanding state. That is where extradition is permissive. And that's where, under the bill, it would be prohibited if the act was related to legally protected healthcare.
Conducted in Maryland, though.
Correct.
Yes.
Correct.
That they made illegal.
If the crime
That they made
occurs,
illegal.
Texas
Yeah,
has made it illegal
I got
now.
you. Yeah, no, okay. I mean, I know this is all surrounding like healthcare, but this is still about the extradition and laws of differing states being enforced elsewhere. Okay,
Yep, and insurance premiums and, health licenses.
okay, thanks.
Oh, sorry, Miss.
I just had one question. In all the testimony that we heard, was there any examples given? Data, examples? Yes. Anything,
Not in Maryland.
the largest scope.
Not in Maryland. There's a Senate, there's a legislation that's in Texas that was used to explain, it's like, for instance,
But we don't have an example.
not in Maryland, no specific examples in Maryland.
Okay.
A lot of this
So we don't have an
is
example.
prophylactic.
Okay.
I want to make sure that everybody has a clear understanding. So like the healthcare practitioner. So if someone from Texas were to come to Maryland, the healthcare practitioner would perform a procedure. The person goes back, and then Texas all of a sudden wants to charge the practitioner for performing said. That's what this would be about, is that so another state can't charge what is legally permissible in this state, even though I'm opposed to it. It's legally permissible in this state to another state's law.
So yes, in that scenario, let's add one other fact to it. Let's say the person was licensed to practice medicine in both Texas and Maryland, and they were sanctioned, like they've got their license pulled in Texas. This would protect Maryland from saying, hey, look, Texas, you do what you want to do, but Maryland, your license is still going to be protected here in Maryland.
Gotcha.
So just to respond to Senator McKay's concern, I think this bill is proactive. We're anticipating that other states are going to do. In Maryland, we have rather extreme abortion laws on one side. I voted against or intend to vote against the one on the floor about the amendment. I think it's extreme. In other states, there are extreme abortion laws on the other side. So other states are trying to find ways of reaching out to states like Maryland and prosecuting people or extraditing people from this state to other states so they can stand trial. So this tries to protect our people in Maryland who are doing what's legal in Maryland from that kind of conduct.
Oh,
Next year.
yeah, I just wanted to also address Senator McKay's concern a little differently than Senator West did, but I support everything he said and just want to add that the testimony we heard was really about what a chilling effect the threats of these laws being enforced has on our clinical providers in Maryland. And so I think it's really important that we act on this now because we want to make sure we do have access to care in Maryland, and that the fear that has been created by these types of actions is what we're trying to stamp out. So that's why I think it's important we address it now as opposed to wait until we have terrible stories.
But we stripped out feelings and fear. But I get it.
Vice Chair Wallsteiger.
Oh, yes. I mean, yeah, yes, on the bill as amended.
Senator Sidnor,
Yes.
Senator West,
Yes.
Senator Muse,
Yes.
Senator Folden,
You can pass if you need to pass.
Pass.
Senator James,
Yes.
Senator Washington,
Yes.
Senator Kelly,
Yes.
Senator McKay,
Nay.
Senator Carter,
Yes.
Senator Smith,
You go back to Senator Folden first, and then back to him.
Senator Folden,
Yes.
Senator Smith,
Yes. Bill passes with amendments 10-1. All right, hold on. Yeah, it's better. So we're gonna go to Sumari with Senate Bill 579.
Senate Bill 579 prohibits exclusive listing agreements for the sale of residential property from being effective for more than 1 year. And it requires the State Real Estate Commission to include an assessment of the use of exclusive listing agreements in an annual report. There's an amendment in your packet. The amendment strikes the bill in its entirety, creates a new subtitle, Subtitle 8, Residential Property Service Agreements, based on the Model Act. The amendment defines terms. It establishes that the act is prospective only and lists exceptions. It establishes that service agreements are effective for a year or less. They can't run with the land. They can't bind subsequent purchasers. They can't create a lien on the property or allow the service provider to assign rights under the agreement without notice to the property owner. It provides that violation of the agreement is an unfair, abusive, or deceptive trade practice subject to enforcement and penalties under the Consumer Protection Act. The amendment also prohibits the recording of the service agreements in county land records. It establishes that the recording of such a service agreement is not a notice of a lien to a subsequent purchaser of the real property. It also grants a cause of action for compensatory damages and attorney's fees against the service provider.
Now, can you explain the amendments? Where did they come from, and is this the model?
These are
model-
the model act, or this is the model act suggested by I think it was Maryland Realtors. It's been enacted in several other states. There's been litigation against providers of these exclusive listing agreements for unfair trade practices. And the arguments raised by those providers is that the exclusive listing agreement, the agreements at issue weren't actually exclusive listing agreements. They were more agreements to enter into a listing agreement sometime down the road. And so this model act better captures the intent of the bill by essentially expanding what counts as an exclusive listing agreements and just terms it service agreement, and the amendment defines that. And so with the amendments, the AG actually wanted a broader definition. I didn't receive any amendments from them or from any sponsors that would expand the definition that would be captured by this bill. And so as amended, as well as the original bill, I believe it just limits the applicability of the bill to, give me a second, 4 or fewer single-family dwelling units, and the OAG was asking for a more expansive definition.
All right, so the amendments have been adopted. Now the bills before you as amended. All right, it's been a motions for a favorable. It's been seconded by Senator West. Is everyone okay with being recorded in the affirmative? All right. Let's see what it is. So it's Senate Bill 487.
Senate Bill 487 amends provision of the criminal procedure article to explicitly prohibit a person, including an incarcerated person, from violating a pretrial or post-trial condition that prohibits the person from contacting, harassing, or abusing an alleged victim, or going in or near an alleged victim's residence or place of employment if the person is charged with committing certain offenses. There are no amendments in your packet.
That was quick. Motions for a bipartisan motion for favorable has been seconded. Everyone's okay being recorded in the affirmative. No constitutional issues is the one, right? Senator Walter? Okay. All right. All right. Shamari, let's go to Senate Bill 56, please.
Senate Bill 56 prohibits a provision in a contract with the design professional for professional services that requires the design professional to indemnify or hold harmless the promisee's independent contractors, agents, employees, or indemnities, or any other person against loss unless the design professional is the proximate cause of the loss. The bill also adds highway or road to the list of contracts that a design professional constructs. As amended, number 4 of, if you look at the reprint, that's on page 3, is stricken from the bill. It's in its entirety. And adds a number 5 that the subsection may not be construed to prevent enforcement of a provision in a contract or agreement that purports to require a design professional to indemnify a promisee or indemnity for defense costs incurred in connection with third-party claims for loss or damages caused by or resulting from the faults of the design professional or its derivative parties, except to the extent the provision is against public policy and is void and unenforceable under paragraph 2, 3, or 4 of the subsection.
The wording and tell you what this is about.
Yeah.
If there's a construction contract going on, project, and there's an accident and someone gets injured, whoever caused the accident, whichever company working on the project that caused the accident should bear the liability for the accident and tender it to its insurance company. So its insurance company pays for the damages resulting from the accident. But for some years, the state of Maryland has done in some of its contracts with architects and engineers is to include a provision that says, no matter who was responsible for the accident, you're going to pay for it. And the problem is the architects and engineers cannot get insurance to cover that. So it becomes, to sign such a contract is a bet the company decision. If there's no problem on the site, you make money. If there's a big problem, you could go under if you're small. So small engineering firms, minority-owned engineering firms and architectural firms don't bid because they can't sign these contracts. So what this says is whoever caused the problem, you're responsible and your insurance company should pay for it. And of course, anybody on a job has to have insurance. That's a requirement of the underlying contract. So this only makes sense. This is the third year this bill's been brought. The past 2 years, the Attorney General's consumer protection people took a negative position. This year, the new Attorney General has backed off, is taking no position on this bill at all, is not opposing the bill. So there's no opposition so far as we're aware.
It really removes some of the hindrances that minority businesses have to getting contracts, almost like the insurance part of it. You insure for the entire cost of the building and not just what you're doing. It starts to kind of chip away to make it easier for minority contractors and small businesses to be able to bid for larger contracts. So yeah, move favorable. Second.
There was an amendment. I think I did explain that.
I want to make sure we adopt it though. So can we do that? All right. It's amendment's been adopted. Now the bill is before you as amended. Further discussion. So motions were favorable and seconded. Is everyone okay being recorded in the affirmative? Okay. Senate Bill 56 passes unanimously with amendment.
Senate Bill 411 repeals statutory provisions that establish the annual compensation of orphans court judges for Prince George's County and instead authorizes the county executive and county council of Prince George's County to determine the annual compensation for judges. Pursuant to constitutional requirements, any salary adjustments take effect at the beginning of the next term of office. There's a delegation letter in your voting packet.
Motions were favorable. It's been seconded. Senator McKay is singing Kumbaya. Now the bill is before you. Everyone's good. All right, sweet. All right, it's been bill passed unanimously. Okay. All right, Senator West, we're going with Senate Bill 211.
Senate Bill 211 authorizes a court to place a defendant on probation before judgment if the court finds facts justifying a finding of guilt and makes corresponding statutory changes to account for this and establishes procedures and requirements for a probation before judgment granted under the bill. There's an amendment in your packet, which is number 263521. What this does is it breaks this new probation before judgment procedure into a new subsection. It adds a requirement that the state consent to such a probation before judgment. It clarifies that the facts found must justify a finding of guilt beyond a reasonable doubt. And it requires that in order to grant such a probation before judgment, the court must find that doing so is in the public welfare.
So if I could speak for a moment, Mr. Chairman. So as of this morning, all the stakeholders are on board and their concerns were addressed in the amendment and resolved in the amendment. So there's no opposition to this bill as things currently stand. The bill is important because as things stand right now, to get a probation before judgment, they actually do put a judgment on the record and immediately strike it, but it's on the record. And this means that people who want to get jobs in national security can't get jobs in national security because there's a judgment on their record. If people are licensed in the healthcare professions, they could lose their license to practice healthcare because a judgment was put on their record. And I think most significantly, people in this country with green cards who are legally here and student visas who are legally here, once a judgment goes on their record, they can be deported immediately. So a student halfway through college is sent back to his home country and can't complete his college education. There's just such palpable unfairness in the existing probation before judgment provision that's why this is a separate route to getting a probation before judgment, which does not involve a judgment being put on the person's record unless the person violates the conditions of parole. At that point, the judgment does go on the record and the person gets the appropriate penalty for whatever he or she did. So this is a very, very much needed bill. We've tried to get it for a couple of years now, and this year I think we've resolved all the objections. So I hope everybody feels comfortable in voting affirmative on this bill.
Thanks for all of your work. We've had this bill for a number of years and I just have a question. I'm not like, am I allowed to ask a question since everybody's apparently so happy with it? I mean, it's not really a question. It's more that I guess we'll see. I don't know that this really truly achieves the goal. And the reason that I say that is in my experience, when people apply for things or have background checks and the like, they also look at whether there's something pending. And this is still going to be unsatisfied, right? Like it's still going to be that the court may find facts justifying a finding of guilt beyond a reasonable doubt, defer the entry of the conviction and enter the probation before judgment. So a background check or other kind of inquiry is still going to reveal that there's this case out there pending. I am not trying to destroy anyone's dreams, but I didn't discuss this with anybody. And having practiced for quite some time and dealt with a lot of people that have issues, this is something that I think is still problematic.
But just, can you answer the question? I mean, the immigration consequences, which is a major thrust of the bill. I mean, this affects everything, not just immigration cases, but those immigration consequences will still be remedied through this mechanism that you've created here.
My understanding is that the standard that ICE uses is a conviction on your record. If there's a conviction and you're here with a green card, my understanding is that ICE if there's a conviction on your record, ICE has the authority to swoop in and deport you immediately, even if you have got a green card and even if you have a student visa. So that's the trigger. Now, whether or not ICE would change the standards and expand them, that if they're merely charges pending, at the moment, that's not what ICE does.
Not under this administration, but.
So I think the immigration consequences trigger because they trigger when you have a conviction, and the Immigration and Nationality Act defines conviction to include a no-low plea, as well as any situation in which the defendant admits facts justifying guilt. So it's a problem in federal statute specifically.
So that in this case, we've drawn this new legislation so that you don't admit facts.
Yeah.
And you don't enter a no-low plea, and no judgment or no conviction is entered on your record. So we think we're threading the needle to protect these people. And that's why this bill was drafted.
All right, Senator Foley.
So you're saying that all the stakeholders are now on board with this, so the Maryland Judiciary, but I don't, the Judicial Conference, so I don't have anything other than.
No, we don't have anything in writing. I had a meeting
So-
yesterday with Chief Judge Morrissey and other circuit court judges and, excuse me?
Because when I read it, it's talking about how the Virginia statute's different than what we're doing here. Was there something that we've changed?
We changed, that's why this amendment. If you
The
look at
amendment,
the language in the amendment is markedly different than the language in the original bill. And it's that way because that's what the judiciary asked for.
okay.
Thank you. So a couple quick things. First of all, I want to thank you for the eloquence with which you express the purpose of the bill and the merits of the bill. No one should be kicked out of this country for a minor offense. It's just, my grandfather was fleeing persecution of Jews in Poland. If he got some kind of minor offense, the idea that he would be sent back is terrible. So I appreciate what you said earlier. I want to follow up on Senator Folden's question in terms of the timeline. So as of last night, it was indicated to me that this kind of kumbaya meeting happened with the judiciary, as well as your state's attorney who agreed with the bill. But I received notification that the State's Attorneys Association itself, as of last evening, was still in opposition to the bill.
Line here. It was my mistake, really. My state's attorney, Scott Schellenberger, was in the meeting yesterday. We had people in my office around a table and the judiciary was on a Zoom. And we all reached that kumbaya moment at the end. And Scott said, I'm for this. I assumed that Scott was speaking for the State's Attorneys Association. That was not correct, as it turned out. And Mr. Kroll.
We also have Steve Kroll here as well.
Who's in the room.
Yeah.
Said he needed one more word, the word consent, added to the amendment to make it clear that the state's attorney had to affirmatively consent to the probation arrangement that was worked out between the state's attorney and the defendant or defendant's counsel. And so overnight, we massaged the amendment further to include the word consent. And with that, Mr. Kroll today indicated he was now on board. So, and he representing all the state's attorneys.
Understood. Okay. Well, with that, let me just give a very hearty thank you to you, Senator West. This is 3 years in the making.
Yeah.
And it's been really tough to find consensus on this bill over years. I think our good friends and professors at the University of Maryland who worked on this bill took a really strong kind of problem-solving mindset this year, which was constructive to getting this passed. So, but most of the thanks is for you, because this was a tough nut to crack. And I struggled with it previously, but you really put together an amazing work product.
Well, in
So thank
fairness,
you.
this is what we do in this committee, whether behind the scenes in my office or behind the scenes in the conference room or here in public on a Zoom. We work together, we sit down, and generally we can work things out. So I think it's a testimony to the work of the committee, not just me.
No, here, yes, and just as another foot stomp, but that every time we meet, it's always in accordance to and adherence to the Open Meetings Act. So so Dia Daly, if you hear me, we're all squared away. All right, Senator James, go ahead.
Senator West, I just need, I'm a little tired, don't want to read this whole thing right now and slow you down, but I just want to know, have we completely gotten rid of our former probation before judgment?
No.
Can I finish the question for just a second and then you are go for it? I'm sure you'll be eloquent. Or have we retained that and now created this new vehicle that I guess we're calling probation agreements? Is that what we've done?
Yes, the original draft of the bill, which I really wasn't responsible for, was very confusing because it confused, it seemed to mix everything up together. And so about a week ago, I made the decision we're going to leave the existing probation before judgment alone. It's worked for many years. We're not going to touch that. We're going to have a second part of the bill, which or this of the code, which covers this alternative route to get a probation before judgment. So to answer your question specifically, the original probation before judgment remains intact. This is just a new route, which people in these kinds of circumstances can avail themselves of in order to prevent deleterious consequences.
And in order to use this new procedure, if I understand, the state's attorney must consent. The court must agree.
Yes,
Those the two
yes.
requirements.
You have the defendant who is agreeing,
Well, I would.
you have the
assume
state's attorney who's
the defendant would
consenting,
agree.
and you have the court who listens to the proposal and says, okay, I'll adopt that proposal.
Well, I think that was the right way to go because I thought it was hopelessly
It was very complicated,
unfixable
very
and
confusing.
Getting an alternative is a better choice. Thank you.
Thanks.
Thank you. Senator West. So you had talked to this provision in the example of somebody here on their green card and education. So that fixes that. But what about the person who's here illegally?
A
Does ICE
person who's
still-
here illegally is subject to being deported at any moment. At any time, ICE can come in and arrest them and deport them.
So you've
So
not,
this doesn't affect that one
so
iota.
you've not created a
No,
get out of jail.
exactly.
Okay, thank you.
All right, so can we adopt the amendment? Second, everyone's okay adopting the amendment? All right, now the bill's before you as amended. Motions for a favorable. All right, so withdrawing, so I'm withdrawing the motion, and there's another amendment to be added to the bill. Senator Muse wants to be added to the bill. Senator James wants to be added to the bill. Senator Waldstreicher wants to be added to the bill. Senator Smith is already on the bill. All right. Is everyone okay adopting the sponsor amendments?
Muse, James Wallstreet.
Yep, Muse, James, Waldstreicher. All right, now the bill is before you as amended. The motion's been for a favorable. It's been seconded. Is everyone okay being recorded in the affirmative? Excellent. Good job, Senator West. We're gonna call 546 next, and then we're gonna go to 742. Okay, so.
This bill alters provisions related to criminal immunity and sanctions for violations of pretrial release, probation, or parole for individuals who seek, provide, or assist with the provision of medical assistance or medical emergencies involving the ingestion or use of alcohol or drugs. As I mentioned yesterday, in your voting packet from yesterday, I just included copies of the bills that took the existing provision of law from where it started, I think, in 2009 to where it is currently. In the past, that's sort of been helpful for understanding the this provision of law.
Thank you, Mr. Chair. So as I read this, we're now creating a carve out for yet again another classification for a person who is experiencing a medical emergency to be involved in an assault and no accountability and not responsible for those actions that were a part of what precipitated that and resulted in that. Is that correct? Because the way I read it, we're doing exactly that. If you shall be immune from criminal arrest. So this just seems like a wonderful defense to throw up to say my client was clearly so intoxicated he had to be on medical duress and can't be responsible for those actions of killing that family.
I understand what you're saying, but the bill is a part of what we call the we started off with the Good Samaritan bill. Somebody who was helping somebody who had an overdose. Rather than leave that person on the ground to die because you're afraid of prosecution, you call and you can be let me finish. You call in and you're not going to be prosecuted. This does the it's pretty much the same.
So if a family member is having a medical duress and a spouse goes over because he's been drinking or doing drugs, and a spouse goes over and tries to render aid to him and he kills her, he would be immune from criminal liability. This bill, we're trying to overly simplify something that is very much more complex than a simple check it off and go. This would create an immunity to that.
Well, so the immunity for arrest, charge, or prosecution applies if the evidence for the, and this is just for clarification, applies if the evidence for the criminal arrest, charge, or prosecution was obtained solely as a result of the person seeking or receiving medical assistance.
So if the person assaults their, he's trying to render aid. If this is their argument, I was drinking, I did drugs, I was having medical duress, I didn't know what was happening, my heart was pumping, my wife came over, I hit her upside the head to defend myself because I didn't know what was happening. She hits her head on the edge of the counter and dies. This bill says that we cannot, immune, it says, shall be immune from criminal arrest. So this creates a defense for such an assault.
Well, there's already existing law, like in this section. It's not all new code here, but just so I'm understanding the question, is it you're saying that the situation is the person, the police wouldn't have shown up, but for the fact that somebody was seeking medical assistance in response to an overdose, and that's the only way that they became aware of
Yes.
the assault or
Yes.
a homicide
That's
or
exactly
something
what I'm
like
saying.
that. I don't think I have a great answer for you.
If you don't have a great answer, I don't think we have a great vote going right now. That should be a concern to anybody, because this is something that we did when we started this immunity from prosecution. The merits of it at that time, I understand them. But this seems to go into a whole nother like potential, like I just have concerns with where this is, that you could be immune from prosecution or from criminal arrest.
Right, so that's. So that's the point. At one point in legislative history, so.
I guess the question was on subsection C. At one point in the legislative history, it was in the first person. I believe in 2014, the language person who reasonably believes was added. What this is doing is in subsection C, it's saying that a person who is experiencing a medical emergency, and then there's additional language being added into to subsection D there. So I think that was the question.
I thought that I understood it, and maybe I'm just tired and it's late, but isn't this only dealing with violations of release? Is there something added that I'm missing?
This has already gone in, but we have literally. So we're taking out the bracket, we're adding in who's experiencing a medical emergency in accordance with subsection C. Provides or assists the provision of medical assistance. Yeah.
If I may briefly respond to your question.
Yeah.
So the language is actually even more narrowly tailored. If you start reading at the line 7, sorry, I'm doing this from my phone because my laptop died, but line 7 on page 2, it's reading about what the person will be immune from. And it articulates the specific offenses that the person is immune from. You will see that 2204 is not listed in there, which is second degree murder. 2201 is not listed in there, which is first degree murder. Moreover, if you continue reading, you will see that it says if the evidence for the criminal arrest, charge, or prosecution was obtained solely as a result of the person seeking or receiving medical assistance. So in your circumstance, there would be, you could have numerous other ways to obtain both evidence and to render charges against that person. For example, if the wife in your example seeks medical assistance, that takes it outside the scope of the person receiving medical assistance, moves it into her being the victim receiving medical assistance, would permit charges. If there was evidence of an argument or any other call or any other physical evidence to her body that was introduced, that could all be introduced because none of that would be obtained solely for the purpose of rendering medical aid to the person experiencing the initiating medical emergency, which is the overdose.
What is 601, 619, 620? I mean, what are the subsections?
So 5601, the 5.6s are your controlled dangerous substance offenses. The 10.1s are your, sorry, and also, yeah, that was an oversight in my reading on it. The 10.1s, let me just pull that up for you, Senator.
I don't have it on my phone. It's too hard for me. I apologize.
Yeah, the first part-
Crimes against, so it's crimes against public health and safety. Those are, I'm just going back and forth here. 10.114 and 10.116, 10.117. That is right, alcoholic beverages. So underage possession, false documentation, obtaining for underage consumption, furnishing. So it's, yeah, it's extremely more limited than that and wouldn't include second degree assault.
No, thanks. Senator Vaughn, I see what you're saying. Like, apart from the offenses, but switching it from the first person to the third person, it's confusing. Yeah. No, you're good. I just, the way you're reading it, I read, yes, I get it.
But now it's much more.
Yep. There are no amendments here, are there?
No, there are no members.
Got it.
No favor.
So motion for favorable and seconded. Is everyone okay being recorded in the affirmative?
I'm still.
All right, so Senator Fulton is down.
But not as fiery.
So the bill passes 10-1.
Now just against the request.
Senate Bill 742. Josh, you're up.
Senate Bill 742 requires that any system operated by a manufacturer, distributor, or factory branch of motor vehicles or an affiliate of such for the allocation of new vehicles to dealers be reasonable and fair for all dealers. Upon written request from a dealer, a manufacturer, distributor, factory branch, or any affiliate must disclose the method by which new vehicles are allocated to dealers of the same line and make. In any dispute over compliance with the requirements of the bill, a manufacturer, distributor, factory branch, or affiliate would have the burden of proving compliance with the bill.
I didn't submit an amendment, but I don't, this bill has 3 sections. The third section shifts the burden of proof. I don't think we should lightly shift burdens of proof. I mean, that's what the law provides. And just because some stakeholder wants to shift the burden of proof, I think we ought to ask a lot of questions before we do that. Because the standard is the plaintiff has to prove his case and the defendant is defending. So the burden of proof is always in Maryland on the plaintiff unless we as the legislature decide to shift it. I don't see a strong argument here for shifting it. I'm in favor of the first two sections, but not the third.
So again, I'll just prompt you. So what are the other sections which the burden is the same?
So there are a couple of sections which use similar language in this subtitle, which deals with the relationship between manufacturers and dealers. So in Transportation Article 15-207E3, that provision requires that any performance standard, sales objective, or program for measuring dealership performance must be fair, reasonable, and equitable. And additionally, in any dispute over that requirement, the manufacturer would similarly have the burden of proving compliance. And then in section 15-212 subsection C, this also contains a burden shifting provision. That section deals with disputes over the manufacturer reimbursing the dealer for repairs done under the vehicle's warranty. So that's just the other areas in the code where similar provisions exist. The first one was Transportation Article 15-207 subsection E.
Yes, just in response, if we made a mistake in the past, we shouldn't compound it now. Really? No, I.
So my comments are the overall of the bill. So I just don't understand why we're getting in the middle of the relationship between the dealer and the manufacturer. Is this going to be the camel's nose under the tent that we're going to do John Deere tractors next year, that they're not bringing the right John Deere tractors in that everybody wants? And then is it going to go to it? I mean, at what point does the contractual remain between the manufacturer and the dealer? Either you want to sell the product, you don't want to sell the product. Who are we to say?
What is the governing principle?
Yeah, I mean, open up the next. It's bad policy.
Thank you. So, Mike, I appreciate, Senator McKay, I appreciate what you're saying. And so I sat on ECM for 4 years. And if this were our first foray into this relationship between manufacturer and dealer, I would agree with you that ultimately the market should make these determinations. But having sat on that committee, I see, and you can't see it just by looking at this bill, but that there's a whole section of law about the relationship between manufacturers and dealers. The relationship between manufacturers and dealers is highly regulated, very complex, and is done at the state level and has decades and decades worth of history of state legislatures defining a policy outcome that we want in this area of regulation. And so it's kind of like in for a penny, in for a pound. If we're already regulating in this area, it's appropriate for us to make policy choices as a committee. In my view, this policy choice is one that is fair for the dealers and, to be honest, fair for the manufacturers, who are making sure the dealers are the ones who best know their customers and can best allocate what their customers want. And so if we're already regulating this relationship and this policy outcome is one we support, I think this bill is an appropriate use of our continued authority.
And we do have a history of doing that here in the legislature in years past, when situations arose in which one area felt as though we're not getting the best product for one reason or another, and we should not have to go 100 miles away to get what we know we should have in our community. This is what the dealers were arguing. I'm not getting, what some of them were arguing. We want the same rights to get what everyone else is getting. And there seemed to have been a turf war at one time going on. So my point is, we have gotten involved. We've had to get involved. And I think that is our role, even here with this bill.
Yeah, I just think, I mean, look, and from the consumer perspective, I mean, ensuring that you have access to some of the, not only the more in demand, but more environmentally sound vehicles and asking for that level of transparency. I mean, I think is, yeah, fine. Maybe. So Senator McKay, and then we'll go back and forth, and then I'll wrap it up at the end, and then, we'll see what the will of the committee is.
So. That's all right. So. As I understand. We have precedent that we've been in this relationship. There's been. Incidents that we've had to get involved with it. Because. Of past experience. And that is why we're getting into this. And I know I was by myself on a previous bill. But the reproductive, you could not give me a single piece of evidence, but yet we had to get into this bill. And I just, probably not fair, I apologize. But anyhow, thank you.
So I just wanted to, for the information of the committee in fairness. Yesterday I had concerns about this. I expressed those concerns. I was contacted today and I had a very good discussion with the person that represents the auto dealers in Maryland. And I think I was misunderstanding some of it, thinking that it was a local level allocation for like is somehow distributed once they get to the state. This is from the manufacturers. And the issue that happened was, you could have a large manufacturer who could literally, if they chose to, cut off a smaller production mom and pop dealership by saying, you know what, we're not going to move these vehicles to you. We're going to put them out on this other dealer, and cause an unfair advantage to one of our local businesses. So while yesterday I had concerns about it, getting this clarity was helpful for me because the last thing I want is an inequitable distribution caused by a manufacturer. And, it's not like we're in Michigan or Detroit where we're right there and that's the manufacturer, but this is for all of them around the globe when they come in the United States, how they're distributed. So that gave me better, for what it's worth, gave me better calm and peace with this.
Senator Folden, by what he understood, may answer the question I was going to pose, which was what is the history? But I think if I hear this correctly, the reason we have a history of regulating in this area is that the relative power dynamics between large manufacturers nationally are so much more dominant than any small dealers locally. So we're not getting in because we want to play around with the market, but we're recognizing that in some circumstances, the market forces really aren't working, that we have, I'm using monopoly, but a very large entity that has so much power over smaller ones. There's no meaningful negotiation. Is that would be correct to say that?
What was said to me, what was proffered to me was that there was an example, like they wanted to do something, they wanted to implement a new policy. And if the dealership was kind of resistant, like, well, this will affect us, we don't want to do this policy. They could be like, well, you know what, we're just not going to give you any vehicles and we'll just ram it to you. And the manufacturer has the ability to do that and cause that harm. So
it's putting it legally, the two parties are not equally.
Yeah, they could change the contract. The manufacturers could come in and change the contract at any time, and there's nothing that.
Right, there's
holds
an
them accountable.
inequitable
Yes.
power dynamic between the parties, so that's why we
Yes.
regulate in this area. Because I don't want us to get into the habit of
Correct.
picking winners and losers
Do I?
and micromanaging economies and business. But if
Yes.
this has that purpose, that's been well recognized in the United States. So for that reason, I'll support this. Thank you.
Senator Folden. So we had the opportunity to discuss this, you and I. And as I said to you, the locals are fine with this. The dealerships are fine with it. And you said, and then you said, and then now we're here.
And come on, now he's seen the light. All right,
And
come on,
so-
Senator McKay.
And I apologize.
Something you gotta, buddy.
I was,
Holy Toledo.
I appreciate your support and I apologize. I thought that he had contacted you as well. So I'm sorry.
We're working the magic here in JPR, all right? We're
I'm
working the
sorry.
magic. All right,
I still love you, Michael, very much.
all right. Senator West, go ahead. And then we're gonna vote this.
I-
We're,
Love this. I'm not seeing y'all do this.
There's a long digression, but I would like to pursue my amendment to get rid of part 3. The shifting of burden of proof. I haven't heard anybody argue against that.
so there's an amendment for us. I'm not gonna second it, but you know, it's out there. He wants to switch the burden shifting on them. So now it's on the manufacturers wants to switch it or can't, or
Well, the current burden is where it always has stood. It's on the plaintiff in any case. This bill would shift the standard burden that applies
under the bill, yes.
under the bill. The standard burden would shift and all of a sudden it's the manufacturers in any case that's brought that have the burden of proof. I just think that's wrong. That we should not shift the burden of proof unless there's some mandatory reason why we should do it. And I've heard no such mandatory reason in this case.
All right, there's no second on that motion or that amendment, so we'll draw it. So this motion for favorable on the bill, it's been no, there's no amendment on the bill. No amendment on the bill. No. This clean bill has been motioned for favorable. It's been seconded. Do we need a roll call? And then we'll switch. Senator Sidnor, go ahead.
Chris has now made me curious.
We have, just so you know, we do have a motion. It's been seconded before us. So we can roll it on the favorable then, but if you want to come back, you can come back if the
No,
favorable fails.
I'm just trying to, I mean, if you as a sponsor, is there a reason why it was drafted that way?
Just because, so in France, you can come up and talk more of it, since you're the one that. You pointed out the 3 other sections in that council read in which the burden is on the manufacturers, not the dealers. But in Pennsylvania and neighboring jurisdictions, this is the same thing. So Franz, you can provide more context.
Sections, and I think we read some of them throughout 15207 that actually put the burden on the manufacturers in terms of the market areas that they established for the dealers, in terms of making sure the performance standards are accurate, even in terms of if a person who operates a dealership dies and the dealership appoints a replacement, and the manufacturers have some right to veto the replacement to run the dealership. But even in that case, we put the burden of proof on the manufacturers to establish that that person would be unfit. So there are 3 or 4 of these cases throughout 15207. And, you know, in this context, actually, it is normal to put the burden of the proof on the manufacturers. And part of the reason, of course, is we've talked about the power imbalance. Also, in this case, when we're talking about the distribution of cars, you know, dealers are retailers. They don't really have the data to be able to show how the system works in general. They have a clear impression that it's not working fairly for many of them. But in terms of the data about production and how it gets allocated, really it's the manufacturers who have that data. So they're the ones, you know, who run and operate the system. Seems to me it makes sense for them the burden to be on them to explain how their system works and why it's rational. And they're really the only ones, I think, who have the information to do that.
I just want it, committee, council, could you just tell me again where it not only says it has to be fair and reasonable or equitable, but the burden is on the manufacturer? Because the paragraph that I read is so awful. It's so long, 3 little Roman numeral 2 is like the worst run-on sentence God ever created. And I don't know if it's saying that or not, but is that what you were relying on, that paragraph?
So
Oh, I'm sorry. Sorry.
Yeah, so what I'm looking at there is subparagraph Roman numeral 3. So a manufacturer, distributor, or factory branch has the burden of proving that the design of the assigned market area, performance standard, sales objective, or program for measuring performance is fair and reasonable under this paragraph.
Right. Now go and tell me where it says the burden, where the burden is. I got the fair and reasonable part. Because the way I read it, it says a dealer has to go to court and file a claim, and a court of competent jurisdiction will determine the merits of that.
Okay, section, the bottom of page 15207.
Oh,
Section-
look, sir, I don't
I'm sorry.
have pages.
I'm sorry,
listed.
section, I think it's section
But before you go on, I just want to make
4H2.
sure we're skip, there isn't, it's in the paragraph you were looking at, we don't have that language. I don't see it in the little Roman numeral 2. I see the fair, but I don't see
Some-
the burden on just read it of compliance on the manufacturer in that paragraph.
If I may, it says.
Can I?
Let's keep counsel.
Yeah,
I need
so
Counsel to talk.
after Roman numeral 2, you have Roman numeral 3, which is a manufacturer, distributor, or factory branch has the burden of proving that the design of the assigned market area, performance standard, sales objective, or program for measuring performance is fair and reasonable under this paragraph.
Well, that's where it is. Thank you very much. I kept reading that god awful paragraph and couldn't get beyond it. All right.
Terrible run on set.
It really, it's, I don't.
Yes.
Yes.
I'll stand on principle, no.
Understanding, yes.
I'm gonna stand on reform principle. Yes.
Yes. Wait, I'm with.
Yes.
Yes.
Because of Mr. Franz, yes.
Senator Carter.
You're dead.
Yes.
Senator Smith.
Yes. Bill passes 10-1. All right, we got one more bill tonight. Senate Bill 789, that's Jamie.
Senate Bill 789 alters numerous requirements for the storage and preservation of sexual assault evidence collection kits. As an example, the bill increases from 20 to 75 years the time after the collection of evidence during which a kit or other evidence cannot be destroyed or disposed of by a law enforcement agency unless certain criteria are met. There is an amendment in your voting packet from the sponsor of the bill. This is Amendment 623-527/1. This is for Senate Bill 789. And the amendment number is 623-527/1. Essentially, the amendment strikes a large portion of the bill, just notably replaces the provisions of the bill pertaining to healthcare providers and pulls from a definition in another section of law relating to services for victims that's qualified healthcare providers. And also includes self-administered sexual assault evidence collection kits, which would need to be transferred to law enforcement agencies by hospitals, child advocacy centers, or other government agencies. If you turn to the last page of the reprint, it includes uncodified language where kits collected before January 1st, 2000 and stored by a hospital or child advocacy center would need to be retained consistent with the provisions of law being amended by the bill. And would need to be transferred to a law enforcement agency for testing within 30 days after being identified as an applicable kit or is directed by the sex assault evidence kit policy and funding committee. Spoke with the sponsor about some concerns about having since that committee is advisory in nature and develops best practices, the sponsor indicated that OAG instead could be the entity that directs those kits to be turned over. Additionally, there's reporting language in the subsection below that, and that pretty much rounds out the amendment.
So can we just adopt the amendment, and then there's another part of the amendment that I guess that's formally adopted with the OAG piece, or okay, got it.
Yeah, OAG piece would be included in that. So it'll be the amendment, but with OAG instead of the committee.
We have one piece to work on. Is everyone okay with that? Okay. The amendments have been moved. Everyone's okay. Further discussion.
Did we address the issue that
The rules of evidence with, as far as marking these, this is the one that we were talking about, like being able to buy an over-the-counter test kit, correct?
Right. So if you look at the last page of the reprint, it provides that the committee would need to make recommendations for, in consultation with the Consumer Protection Division of OAG, educating consumers about the use of self-administered sexual assault evidence collection kits, including information regarding the kit's admissibility in criminal prosecutions and identifying other resources for victims of sexual assault. So it's a recommendation. It doesn't affirmatively, not in this language, doesn't do anything affirmatively about requiring the kits to correct. Yeah, I mean, specifically, I have not looked into the evidentiary issues with that. Obviously,
Well, chain of custody of evidence is critically important.
By that, I mean, I haven't seen if any of our courts have taken up the issue, but that's the correct arguments.
Yeah, they're not
as
going
far
to
as
take it
why
up because they're
wouldn't
going
be
to tell you it doesn't meet the sniff test. It's
Right.
going to be found not usable because it's the chain of custody and who had it. So, I mean, so in the amendment, it doesn't require that to be anywhere on the marking of the kit, correct? You said it's recommended or it may be, but
Right,
it
so they're
doesn't require it.
developing recommendations for how to educate consumers about the use of those kits.
And then the only other concern I have written down that I wanted to research was, I know it's great because there's no concerns about storage or anything right now because this is just being started, but we're talking about holding on to these kits for 75 years. And as a period of time evolves, I mean, evidence rooms are always
Or they donated the space and the racks and everything like that.
for the one in Baltimore,
I understand that.
Baltimore County only, but that's not other places in the state.
I understand, but that's where the bulk of where everything's already being taken.
Okay.
We'll donate some money.
Senator Muse is going to donate some money. It's on the record. Yeah, I mean, I just have the concern about the evidentiary rules of evidence and it not being clearly delineated. And if we don't have something clearly delineated, I think this is a big colossal waste of time because we're setting people out on false pretenses that they're believing this would be evidentiary in value. And we're not clearly stating that it does not meet the rules of evidence.
So by December of this year, you'll have recommendations for that. December 1st, right? I mean, I don't know how fast those get implemented, but you'll have strong recommendations within the year.
So are we bringing this back next year? Okay.
There's a motion for favorable with the amendment. It's been seconded. Is everyone okay being recorded in the affirmative? All right, the bill passes unanimously. 789 passes unanimously. All right, little bonus action. Jamie, Senate Bill 708. Go ahead. Sorry, my fault.
So the bonus bill, this departmental bill requires the Maryland Department of Health to apply to the Criminal Justice Information System Central Repository for State and National Criminal History records checks for individuals seeking to become a youth camp owner, operator, employee, or volunteer who will have access to a camper. To obtain a CHRC, a complete set of the individual's legible fingerprints must be sent to the central repository along with the required state and national fees. The bill also repeals the definition of and eliminates references to youth development organization or program and makes other conforming changes. Expenditures increase 158,000 next year and then up to 205,000 in out years.
To move the bill, motion for a favorable. Is everyone okay being recorded in the affirmative? Excellent. All right. The bill passes unanimously.